get all cleaned up and put away.
Hello, everyone. Welcome to another Friday with Galt Advocacy. I am Dakota. You've probably seen me on here before, especially with Caleb on our Q&As. And today we've joined by a very special guest, our very own Myra Galt, the one who we're all here for, or the one that our business is named after, the founder of our company. Hello, Myra. It's so good to have you here today. Why don't you introduce yourself to anyone who hasn't seen you here before?
Well, first of all, I'm not used to all these lights. They're like blinding me. I want to just say hi to everybody, and especially to my good friends who I know are watching, Lisa, Ramsey, and Vinny, and I think Joel and Larry Rosen. Hi. These are all really important people that do the same kind of work that we do. And I know they watch our videos, so I never get in here. I don't get into this room very often.
No, it's not very often, but
no.
It's fun, right? You get the lights on you. You're in the spotlight.
We got these enormous microphones. Why do we need those?
Oh, they make us sound better. You know, it's easier to hear all the words we say.
Well, I'm
so
happy to be here.
I'm glad. So
are you running the show?
I guess basically, I'll be kind of directing us a little bit, but you are our star today. So
I'm the star.
Go ahead and leave us a comment. Let us know how you're doing. And today we're going to be talking about hearing what it is like right now, the situation, and just what our advice to people is. But so if you have questions about that, it's mostly going to be about IHSS. But while we have Myra here, if you have other questions that are maybe related to our topic, go ahead and leave them in the comment section and share this video with anyone that you think might need to know these things. Anyone who maybe has an IHSS hearing coming up, this is the perfect video for them. But before we get into our main topic, Myra, for anyone who just doesn't know you, do you want to just share just a brief version of your story and who you are, how you got to this position?
I like how he says brief.
Yeah, I know how long this could go.
I have a long story. What can I say? I started this business, I think about 17 years ago now. And my purpose was to be a lighthouse for families who have loved ones that they're caring for. And I never dreamed we would be working with families all over the state of California. My dream began, it wasn't really a dream, it was sort of a nightmare. I had a critically ill child for 18 years. He had a beautiful mind and he was an inspiration, but we lost him at age 18. You knew him.
Mm-hmm.
And he was such an amazing guy. But right before he passed away, I learned about all these benefits that no one had ever told me about. And so I pursued 6 years of studying all the regulations around public benefits, studying law, and learning how to help families. And that's why I opened this company. And that's why we do the work we do. My desire, my heart's desire and my dream now from what I went through was to be there for parents. We gave birth to 7 children. And you have to forgive me, I've been battling a bug. We also adopted 4 kids with special needs. So we had a big tribe.
Mm-hmm.
Like I said, it could be a really long story. I'll write a book someday. So that's me. I am Myra Galt.
And so really, this is what people discover about you when they hear your story, is that you are just like you were back then, just like they are now, learning about this stuff for the first time, having no clue because nobody ever explained it to you, and having to figure it all out in the midst of taking care of 5 kids with special needs at least.
Well, there was one time where we had 6 high chairs in a row and 3 of them had Down syndrome, but it was like boom, 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 boom. Yeah. So I've had my tribe, but yeah, having a lot of kids and having children with special needs, even if you only have one child, and I say only one child who has special needs, your plate is full. The last thing you're going to want to do or have the ability to do is study the regulations.
Oh, yeah.
And so that's going to bring us to why I want to talk today to parents, because their plates are very full and they're exhausted. Most of our parents don't get sleep, even if they've got a teenager. I know one mom, her teenager's up all night and she sleeps by the front door to keep him from leaving. And we were joking one day, she's a single mom, and she goes, "So much for dating." That's not going to happen.
True, yeah.
So I really have a heart of understanding for these families. And I absolutely sometimes I can't relax sometimes when I have had a bad decision, when I know what this parent is going through.
Yeah,
and I have a bad court decision. You know,
I felt that. I felt that. Sometimes I just get so frustrated with how these things happen. Yvonne posted a comment, said, "You were definitely our family's lighthouse." Heart.
Oh, good. Thank you, Yvonne.
We love to hear that, and we are so glad to have you all here. Okay, we got quite a show. So let's talk about the hearing. So a lot of you who've been watching us, who were, I think it was 2 weeks ago, that I mentioned this during the live stream. We posted a video about it, about how few people, especially minors, are getting positive decisions when it comes to protective supervision. We had done numbers. It was about 20%, 22% of adults get approved for protective supervision at a hearing, and only about 5 or 6%, it was 6% of minors get approved for protective supervision. What's that about? Like, what's going on?
So I want to clarify, those aren't just our clients. What Dakota did was he did the research. There's a database that we as professionals can go to. And that database has all the hearings for all the different things in the state of California. And one category is minors and protective supervision and the decisions that come from that. So when he's talking about this percentage, it's for all of the cases in the state of California, the ones that parents represented themselves, the ones where we've represented, the ones where other attorneys or advocates have done representation. This is the outcome. I was actually in a meeting this morning with advocates around the state of California, and we are all saying the same thing. What's going on?
So this isn't normal. Like,
no.
A couple of years ago, you wouldn't have seen it be quite this bad.
No, a couple of years ago is when it started.
It's when it started.
Yeah. 10 years ago, the cases that we lose now, I would have won just like that. So my concern, I want to get the word out about what's happening, because I feel like the public needs to know. And they're not going to know if someone like myself or the other advocates out there, maybe Larry Rosen, I highly respect him. If we don't start telling people, they're not going to know.
Valerie says, "Hello, good to see you both." Good to see you as well. All right. So what is the big change? What's really been so different between the old hearing decisions and what you're seeing now? Like, what's maybe the biggest thing?
Well, just in case there's any judges listening, I respect all of you. Absolutely. You have a rough job. But I think what's happening is it's not all the fault of the judges, and it's not all the fault of the families or the advocates. What I think I'm seeing, and I'm going to kind of step away from the hearing part of it to the home assessment. So what we're seeing is parents, we pushed for parents in the past. You can apply yourself, get your notice of action. If you don't get the services you need, give us a call. We're now saying something very different. What I'm seeing now is parents are going to their home assessments on their own, and they're getting a notice of action that denies protective supervision. And then they're coming to us. Now, these parents don't know the laws, they don't know the regulations, they don't know the rules around protective supervision. So when I get the case and I see that they've done it themselves, then I question them and I find out they said this or that. And I think, oh no, why did you say that? Because the parent doesn't know. They don't know what they should say, what they shouldn't say. And in our meeting today with the advocates, one thing we discussed is that parents don't know what to say. That's the job of the social worker. So,
You mean they should be like asking the right questions,
Correct, yes.
prompting the parents
Yes,
to
give the right
explain
answers.
correctly.
Yes.
Okay. Yeah.
So, what we're finding is, when the parent comes to us and they have a negative notice of action, a lot of times they've already asked for a hearing themselves, or they want us to do it for them, which is their legal right to do. The problem is often what took place in the home where there was no other witness or a professional observing, it's the parents' word against the social workers.
Mm-hmm.
And I'm going to tell you, judges are going to believe a social worker.
Yeah, I mean, it's understandably why. Like, there's a professional versus someone, a lay person. There's the parent has something to gain and social worker
Right.
doesn't. There's maybe some reasons, some valid reasons for it.
Well, I laugh. I haven't ever said this in a hearing, but I felt like saying it last week in a hearing when the judge said, well, the parent the social worker has nothing to gain. I thought, yes, they do. They want to keep their job. They have really good benefits.
It's true.
They want to keep their job, so they're going to do what they're told to do. But I didn't say it. I wanted to. So here's the
for
thing.
any social workers that are here, we didn't mean any. We know that you do this for the love of people, and that you would never, deny people services just because, your supervisor tells you to.
Actually, you were too. We were at a Sillamar a couple of years back, and they did a poll, and most social workers started this work because they loved these people and wanted to help people, just like we do. Unfortunately, they're told to do things they don't agree with, and they now stick with their jobs for job security and benefits.
It's true.
And I know that
was quite a stark contrast of the reason a person becomes a social worker and the reason they stay a social worker are very different things.
And I've gotten calls, you guys, from appeals workers that work for the county that want to jump sides and work on our end. But the reason they won't take the job when I offer it to them is we don't have benefits. We all work really cheap.
Don't say that. No, we do good work.
We do good work, but we don't get paid all the high bucks.
Yeah, no, we can't afford the government salaries. That's what we can't do.
What kind of car do you drive? I'll drive a Kia.
Don't worry about that.
So, oh yeah, that makes me look bad as an employer, huh?
It's all right. We love Myra. So when you were talking about parents, you're talking about parents, have maybe in the past we've suggested they do it themselves and, giving them advice and saying, oh, tell them about these things, get it done. It feels like there was maybe a sweet spot at a certain point in time where the social workers were doing a fairly decent job and parents had been educated quite well in, the right types of behaviors, and whatever mistakes they might have made would kind of get overturned. At the very least, we could jump in and the judges were reasonable. We could deal with them. Maybe 5 years ago or so, there was a certain point in time where that advice worked.
Yeah.
Of do your assessment on your own. If things don't go well, we'll take it to a judge, and that was all right. It feels like that's just not the case anymore.
It is not. In fact, in 2022 and 2023, we got new judges, and they were trained differently. The judges that I had for years before were all older, like me, only they got to retire. I can't. But anyway, they were wonderful. They saw things like if your child ate their poop, they would agree that was dangerous. Now we're hearing in the decisions, oh, that's not dangerous.
Oh, it's just not preferred.
Not preferred
it's
activity.
Not preferred activity.
But it's not dangerous.
Not harmful.
So I'm having to include in my court documents, I'm having to include information from the poison control about how dangerous eating feces can be. So things have really changed. Let me just tell you all, one of the things that we're seeing right now in the state, and this is another reason I wanted to talk to our families out there. We're seeing a huge problem of the counties coming in and taking away the protective supervision. We also talked about that in my meeting this morning with advocates all over the state. What's happening is a person who's had protective supervision for 5 years, 10 years, 8 years, 3 years, even 15 years. I had one. They're calling us and saying, we don't know what happened. They just came in on this assessment and took it away. Why? So when we delve in and figure this out, we find out that they came in, they took it away, and then when they get into court, when you take away protective supervision, the county has to tell the judge one legal reason. There's 4 legal reasons, at least one of the 4. And so they're hanging their hat on this one. They did a more comprehensive assessment than the year before or the years before. And by saying that, they have now told the judge they had a good reason to take it away. Our assessment, when I went in this year, I did a better assessment. Now, maybe they were the same social worker that did it the year before. And that does happen. And then the judge will say, well, didn't you do it the year before? Yes, but the year before, I just wasn't sure. So I continued to let them keep the protective supervision. But then on this year, I asked these questions that I hadn't asked before. And that's why I took it away. Now,
I will say to that, I've seen maybe not as much right now, but maybe last year, a lot more, is that we saw a bunch of people who the social worker said, well, the previous assessment had been right after COVID. We did it over the phone that year. We did a phone reassessment and improved their hours. This time we actually went to the house. And so we did a more comprehensive assessment because of that.
And they'll do that. And here's the thing, you guys. Because your child or your loved one, no matter what their age, has been, even the elderly, have been getting protective supervision, there is no guarantee they're going to get to keep it. And that's what's happening. Now, I heard, please don't mark my words on this. I heard that there has been an encouragement from the higher ups in all the counties to go in and take as many protective supervision cases away as possible. So, and that makes sense to me because the cases I'm getting never should have lost it.
Never would have had to go to hearing before.
Never. So, why is this happening? I don't know. Some people say, oh, it's budget cuts in California and so on and so on. A lot of the budget cuts are not down at the lower level of benefits. They're up at the higher level of bureaucracy over expenditures and such. So what I really want to get out today is if you have not asked for a hearing yet on your denial, don't. Call and get help first. If you have asked for it, go ahead and still call. But be aware that it might not be something we can win at a hearing. And that's what I want to talk about too. So the counties have to get their position statement for the judge and for us 2 days before the hearing. Now, I don't know what if we weren't at your assessment, if none of my staff were there, we don't have anyone else's word, I only have yours. When I get the position statement from the county, it's going to tell me everything you said, or at least what the social worker thinks they heard you say.
Yeah.
And then I'm going to call you and go, well, they said you said this and this and this. Did you say that? And you're going to say, well, yeah, I did. And I want to say, no. We can't win if you said that. Or I'm going to say, they said you said this and this and this. And you're going to say, well, I never said that. They twisted my words. Guess what? It's very difficult to untwist them because I wasn't a witness. None of my staff are witnesses. Nobody can stand up for you and say, no, they're twisting your words. So the judge will believe them over you because you might have the ability to get money out of this deal.
Actually, it reminds me of something we were just dealing with earlier today, of a case where in this case we were at the assessment. I was at the assessment, and now we're going to a hearing. And we look at the county's position statement, and they very much left out some things. Right? They didn't really include everything that was talked about during the assessment. It's a very minimalistic recounting of all the behaviors that were reported. Now, in this case, I was there. I was taking notes during it. So I've written down
You are a witness.
all the other things that we were talking about. So we have a witness. And so it's not just you, the parent, saying, oh, no, I said way more than what they wrote down. Now we have something in writing that was taken at the time. That's good. But if I wasn't there, we'd have nothing. We wouldn't be able to do anything with this case because
you might tell me I didn't say that, or I said this and they didn't add it. I'm sorry.
What can we do about
What can
it?
we do about it
At that point? Yeah.
So you have to know, going in front of a judge is not, it's not like the judge is going to spank the county and say, shame on you, you should have done things better. No, they come at it. We wish. They come at it as if you are the problem, not the social worker. And so you have to understand, when you come to us and you've asked for a hearing, or you want to ask for a hearing, when I say to someone, we can't win, they go, but I'm going to lose all that money. It goes back like 4 months. No, you weren't going to get that money anyway, because you said this or that at the assessment, or you provided a document that was horrible. So when you work with a professional, they're going to go over your documents. So when you come to us, we go over all your documents. We say, oh, we're not going to put that one in. And it's not that we're hiding facts or hiding truth. A lot of documents don't have the right facts. Example would be an IEP. IEPs don't have all the information, and they don't show what really goes on in the home. Yet, of course, all the counties want it and the judges want it. But you know what? There's a way to get around that. And so that is something that we know how to get around in some cases, not every case. The other thing is, when you do it yourself, I have to wait until 2 days before the hearing. And then I find out what the county is going to say about you. And then I find out what documents you gave them. And I find out if you gave them really bad documents. I find out if you said things that wouldn't help your case. And then 2 days before, I have to say to you, we can't go forward. Now, if we go forward and we lose, parents don't understand. This is, the court is ordering, it's a court order that your child or your loved one is not eligible. It's not just a piece of paper, it's a court order.
It basically goes on your record,
sort of,
as far as the county is concerned.
Yeah, on the county's record. So if we want to try and get it at the next assessment, they're going to hold that over your loved one's head. And they're going to say, well, we got a court order here. Yeah. So going in front of a judge isn't the end all. It isn't the answer in every case. What I want to see is people calling for help before we ask for hearing. And if we think we should ask for a hearing, for those families to understand, we may not actually go in front of a judge. We may ask for a hearing so we can work with the hearing representative for the county and settle it, or get a conditional withdrawal or a reassessment. But I really want to caution people from thinking that a hearing is the answer, because they think they're right. A lot of the behaviors that parents talk about at the home assessment don't even qualify for IHSS protective supervision. But they don't know that.
Well, that's part of the experience of working with an advocate. You find out these things. We do have a couple of questions, so we're going to take a brief pause from our main topic and look at these. Now, Maricel, you posted a question. I read it, and I think it's probably too much than we can address right now. And oh, goodness, it covers your head. What? But you did mention that you're working with our lovely Miss Connie Chi. So I would say wonderful. Reach out to her, because it seems like a complicated matter. And then maybe if she needs to bring Myra in on the issue, then she can. But thank you for posting. I would say talk to her first, and then.
Can you put that somewhere else?
All right, here's one. Rosie just said hello, good to have you. I think I saw you tag someone else, so great to have you here at the stream. And then Teresa decided to add a little question to the thing. I believe this is in regards to, we mentioned those who have had protective supervision and then lose it. And you said, well, maybe hold off on requesting a hearing, talk to an advocate first. Teresa did have sort of a question about that. It said, if you lose PS, don't you have to file for a hearing right away in order to get aid paid pending?
Thank you for putting that up in the questions. You're right. I don't want to confuse things here. So if your loved one has had protective supervision and they come, they take it away and issue a notice of action. Call us immediately, ask for aid paid pending, so you get paid while we're going through the process. But let us, and when you ask for aid paid pending, they're going to, I think, automatically put it in as a request for hearing. But the point is, call as soon as possible to get professional help, because what we're going to have to do is we're going to have to figure out what their reason was, what they hung their hat on. And I won't know that until 2 days before the hearing in most cases. So we're going to need to gather a ton of really solid information that shows right now this person still requires protective supervision. What's really interesting, I'm seeing in all the calls that we're getting around the state, I'm seeing that when they tell us they took it away, I say, did you give them a new Associate 21? No. Did you give them a new this document that? No, they didn't ask for anything. So then I have to think, well, what did they establish their position
Right. It's like
on?
they didn't get a new, they didn't, because like you said, their usual go-to is they'll say they did a more comprehensive assessment. But if they didn't get a whole bunch of new documents, how can it be more comprehensive, right?
However, I will say the judges, I hope I don't have judges watching. The judges agree with this, and I don't understand that, because more comprehensive, means what documents did they rely on?
Well,
what has changed?
And oftentimes they just say, oh, well, we observed the child for maybe a longer period of time. Oh, we saw them for a half hour.
Not even.
Maybe not even, yeah.
So I had a hearing yesterday where they claimed to assess the child for protective supervision. The child was almost 4 at the time. They were in the home less than 30 minutes. Yeah. How do you assess all the categories,
including protective supervision,
in a 30-minute period?
I mean, that's barely enough time to just do the paperwork and everything, right?
And I think it's because they came into the home knowing this is a very young child, and in their mind thought, we're just going to deny based on age. And guess what? In the hearing, that's basically what they testified to. Yeah. I hope I win that one. But here's the deal. One of the beautiful things we have in our agency is we have an attorney that does the writs that go to the higher court. And most parents don't even know how to find an attorney that does that. So if we lose a hearing and we were at your home assessment, we know what went on, and we go before a judge and we feel this is a really solid case and we lose, we get a court order and we lose, we have a really good case to go to the higher court, and you don't have to pay that attorney. We don't charge you for that. So this is where people need to understand your data, your evidence, everything has to all go in one direction to make one picture very clear. And that is, without protective supervision, your child or your loved one would be at risk of injury 24 hours a day.
Yeah.
Any other questions?
I was almost prompted to say amen to that.
Oh, we're both church people. That makes sense.
I just felt anyway.
Hallelujah.
Claudia said, I can't wait for you to work on my case, Myra. I'm so glad I went with Galt Advocacy. Love to have you. So glad. And we love to have Myra as well. You do such good work.
Just
all right.
Pray I keep on living, everyone. I'm almost 70.
All right. Callie had a couple things to say here. Said, I was ambushed in my appeal by IHSS workers. And followed up by saying, since when do IHSS not follow doctor's orders and rely just on the IEP?
All the time.
There's a lot we could say about that.
We could have a whole talk
and
on
then
that.
she also said that these 2 new workers knew nothing about her kids.
Well, most of them know nothing about your loved one. And they come in and they spend very little time. And then they think they know your home, your child, everything better than the doctor. And I'm going to tell you, the IEPs are no help. So that's another thing. I hate it when we get people coming to us and they've already done their own assessment and they've handed over the IEP. And then I look at the IEP and I go, oh my gosh, it's so bad. And I can't undo that in a court. I can't undo that. So there is a way to get around that, but I'm not going to share that here because that's company private information.
Well, and like we said, we really don't want to encourage people to
try and do it
on their own because
they're going to lose.
It's going to make it so much harder.
Yeah.
Alyssa had a question. I think this is about adoption assistance. Adoption stipend, age-based as well as care-based, like current regional center. I feel like the question might be missing some context, but maybe this one's. Hello, Myra. I have a question about adoption stipends, and are they age-based?
Okay, adoption assistance is for anyone who adopts a child with special needs. And this was one of the first benefit programs I ever fought to help with years ago. I don't do it anymore. I now just give people advice because there's a loophole in the federal regulations that a lot of the states are using to get out of paying this benefit. So, but what you need to know is when you adopt a child with special needs, whether they are a newborn with Down syndrome or they are a 4-year-old, any child over 3 or a family unit is considered special needs. So whenever you adopt a child with special needs, the payment is based on what their issues are and what their needs are. So if it is a client of the regional center, they're going to get a much higher rate, no matter what their age. When they are not a client of the regional center, then the rate is based on the rates that the government sets up. And every year there's a little difference. And I don't even know what those rates are anymore. But if you adopt a child that ends up being a client of the regional center, even if you started your adoption assistance and they were not a client of the regional center, and then 3 or 4 or 5 years later, now they're a client, your adoption assistance amount can change. So I'm always more than happy to chat with parents about their adoption assistance or to answer questions. My calendar gets very booked, so it's hard to get on there, but I'm always happy to answer those kinds of questions.
All right, we actually got quite a few questions flowing in now that we've started on the questions. People just have so many. So Jocelyn said, what does the reassessment look like after you do get protective supervision? And I feel like there's a lot of ways we could answer it, but.
Well, if you're with us and we're present at all your, when people work with us, one of the things they get is we are going to be there year after year after year for all the reassessments. So we will be a witness. And I have a group, well, Christina manages the reassessment team. Reassessment is a little different than the first time. So in your reassessment with protective supervision, you need to make sure you have current documents. And so because of the way that the counties are coming in now to try and take it away, they are pulling little tricks out of their bag, like they don't ask for updated documents, or maybe they look at the year before and the social worker before, or even they themselves the year before, only spent 5 minutes with the child. So this time they're going to spend 10 minutes with the child or 20 minutes. And they're going to ask various questions. And maybe the year before, there were no questions asked. They just observed. Now they have a reason and a basis to say, well, I talked to the child or the person, and they don't need protective supervision. They're self-directed. And their whole, they're not following the definition of self-direction that's provided in the regulations. So being prepared for your reassessment includes having witnesses. And if you have a witness that's your mom or your aunt or your sister, your grandparent or someone like that, they're biased. So the court will not look at that as a really, even though you're swearing under oath to tell the truth, a non-family member, an advocate, for example, is a better person to be a witness for you than a family member. Although it wouldn't hurt to have family members there too.
Anyway, so the most important thing when it comes to reassessments compared to like the first assessment is your goal now is to convince them that things are the same as they were before. Like, because before you had to actually explain everything, get all the details in. Now, the important thing is to be consistent and to show that things are still an issue, just like they were the previous year. And that's sort of the main.
Absolutely. One of your favorite words to use on your reassessments is nothing's changed. It's only gotten worse.
Nothing has changed.
Now, here's a mistake parents make. So little Johnny, the year before, they told the social worker, Johnny elopes 10 times a day, or tries to 10 times a day. But he's doing better.
Oh, yeah.
He doesn't do it quite as often now. Now it's only 3 or 4 times a day. That's not okay. that is going to say to the social worker, oh, there's a change in need.
Well, and there may
No
and there may
longer-
be a change. Important part is how you say it. Like they say, oh, okay, how's elopement? Oh, he still elopes so often, and then 3 or 4 times a day. Maybe it's not as often, but
you're still
present
concerned.
it as a constant
Need.
As a constant need. All right, let's keep on going. Let's keep on going. So Linda said, so I was denied at my renewal. In addition to the current denial for last year you were working on, should there have been a new form I submitted from the pediatrician? Should this have been done in home? They said it was all online now, so it was a call. Social worker only came to check his room.
No. They're not supposed to just come and check his room. They're mandated.
Normally, the whole assessment would be
Yeah.
at the home. That's
Yeah. And the reason they do the phone was because of COVID. They're not supposed to be doing phone assessments.
Mhm.
If they do a phone assessment and take away your benefit, that's going to be a lot easier for me to fight. Not perfectly easy, but easier than if they come to your home and spend an extra 20 minutes compared to the year before.
Mhm.
But they're supposed to come to your home and go over every category. And if you already have protective supervision, you need to tell them nothing's changed. If anything, my child's gotten worse. Now, if your child hasn't gotten worse, maybe they have improved on a couple of areas. You're not going to hide that, but you're going to say, well, he still elopes. That's not, we still are very concerned, but maybe he can use a few more words. Well, it's okay to say, his speech or his ability to communicate has gotten a little better, but he's still eloping. He's still banging his head. Everything I told you before last year, he's still doing.
shows I can teach you a little more height. All right. What's next? Yvonne said, if you currently have protective supervision, the child will need a conservatorship at 18. Will protective supervision be affected?
No, in fact,
It
it
shouldn't be.
helps. No.
Yeah.
In fact, that brings up another issue.
Okay.
If you have an adult that you're caring for and they are not conserved, when you go for a hearing, they can't sign the DPA 19 form that allows you to go forward in a hearing. If they do, the judge will say, do you feel they're competent to sign forms? And you're going to go, no. Then the judge will say, well, they signed this form. And telling the parent they can represent, or telling me I can represent. So what happens when they're not conserved is then the judge determines that the parent or the person that lives with them will be the one that does the hearing. And so what I do then is I prepare all of the documents and everything, and then I hand it to the parent and I help them know how to represent. But it's better if your adult loved one is conserved.
Yeah, it can cause some problems in hearings, especially particularly when you're trying to get assistance from an advocate or a third party.
It really is. So I encourage you to, I know it's an expense. I didn't want to do it at first because I had 3 that needed it, but I ended up in a situation where I wished I had had it. I've shared that story when I travel and speak about conservatorship, but I know it's a cost. Start putting your pennies aside now. And when they're 17 and a half, call an attorney that does conservatorships. I know our attorney that we send people to is pretty swamped right now, and people are complaining to me that he's a little slow. So if you think he's a little cheaper, but he can take a lot longer, so you might want to start early.
And I think we talked before about there are some other ways you can get like a document preparer or something to, if it's uncontested, can maybe do a majority of the work and then have you do it yourself. There's something along those lines, but I don't know all the details of
Well, I
that.
printed out all the documents thinking I'll learn how to do them because you don't have to be an attorney.
Right.
But the problem is it was overwhelming, and I'm good at that stuff. But if that's all I had to think about and not 80 hearings that are in my queue, I would probably have done okay. So if you, the parent, want to try and do the conservatorship on your own, you go to just Google the state you're in, California, limited conservatorship forms, and it'll bring them up, and there's a ton of them. Or Google how to, what forms do I need to get my adult child conserved? But conservatorship is where a judge orders that you stay responsible for them like you do as a parent before they're age 18. And so what that says, then a judge orders that looks really good, because it says obviously they need more support. And they
when it comes to the protective supervision.
Right.
All right. Callie said IEPs are for school, not home. We know, and we wish that that would have been. Linda followed up and said they used IEP against us, but I couldn't use it to support my case. It's unfair and shady. That is, I feel like this is so true to us, that when we have an IEP and it says even mildly implying that the child is has a certain level of memory or orientation in one way or another.
Yeah.
Even if it's not directly stated, it will be used against you. Yep. And yet, if they have if they are a 15-year-old doing second grade work, that means nothing. They'll say, oh, well, that's schoolwork. That has nothing to do with what happens at home. It's just, there's just no winning when it comes to it.
No. And the thing is, you guys, being that I represented education cases for many years, I don't do that now because I'm too booked with IHSS hearings. What you have to understand is federal regulations that manage and oversee special education come from a completely different perspective. It comes from a positive, what can the child do? And it's goal related. Where are we headed? IHSS is not goal related. It's not it's a needs-based program. So this is where we don't want to sit there and tell the social worker how wonderful your child is. And this is the problem we get when we have relatives write letters. They talk about how wonderful little Johnny is and how they love him so much, or they'll say he's so smart, but
he's so bright,
intelligent, but none of these help. It won't help your case. You have to have eyewitnesses. A neighbor who says, I have seen a little Johnny run out of his house and down the street and the parent chasing after him. I have seen little Johnny run out into the middle of the street and almost be hit by a car. Or a witness that's a ABA therapist. I have seen this child putting non-food items in their mouth. I have seen this child eloping out of this safe area where we're working. You need eyewitness accounts of the behaviors that your child or loved one engages in, or even videos.
Yeah. And this is the thing, is it used to be that we would get a letter like that says, oh, they're so cheerful and so happy and we love them so much, and for a judge, they'd pass over all the fluff and they would get to the meat of it, and that would be what they base their decision on. Yeah. Not anymore. Now you have to cut out all the niceties and just get right to the point and be very direct and very specific about what we're talking about. Yeah. He will run out of the front door. He will run out in front of cars. He does it multiple times per week, whatever it is.
And so many of the behaviors parents are focused on are behaviors that are driving them nuts, like sibling rivalry. Like they have a child with autism and that child is hitting their baby or biting mom. So mom's telling the judge about all these behaviors. Well, they don't qualify for protective supervision. But that's what a mom is living with, or a dad. And that's overwhelming and exhausting. And that's what I had a parent telling the judge the other day how tired she is, how she can't do it anymore. And I'm sitting there thinking, oh my gosh, don't say this to a judge. Because you're basically telling the judge you can't do the job of protective supervision. And if you're saying that to the judge is going to say, then you need to call CPS.
Well, and it's tough because that's, it may be the truth, and that might be really how you're feeling, and you want this person to understand just how much you're going through and how much work you're doing, but that's not how they think.
No, in fact, judges cannot make a decision based on an emotional response. It's by fact and evidence. which is different than the social worker at the home. You could tell the social worker how tired you are because your child is running circles around you all day long.
Mhm.
You barely can go to the bathroom. You leave the bathroom door open. I know, I've been there, done that. Still do sometimes. Leave the bathroom door open so you can know what's going on out there while you're in the bathroom. And how many times do we get to shower? That doesn't happen unless someone else shows up to keep an eye on our loved one. So the person that you're going to tell that to is more likely going to be the social worker, not a judge.
Yeah. All right. We've got,
Any other questions?
we're running low on time, so I'm going to try and
Yeah.
get through these questions, these comments fairly quickly. Rosie said, last year was the first time they asked me for the IPP on the reassessment. I mean, usually the IPPs are better than the IEPs, so
just make sure when you have your yearly review with your regional center that you tell them about all the things that you're dealing with.
Yeah, absolutely. Lisa said, very helpful. Glad to have you. Glad that we can be of help. Callie said, IHS holds no doctor's degree to diagnose the child. This is wrong. We agree, absolutely.
You're preaching to the choir here.
Valeria said, I'm here to learn as much as I can. I'm a new IHS applicant for my mom with moderate severe dementia. I just received the 873 form. I believe my mom is a candidate for PS. I need to ask how. I have an upcoming call with Caleb next week. Oh, well, glad that you're getting in touch with us. I will say dementia cases, I mean, even those are still having issues with hearings, but you've got better odds than
better odds for that than the
for
children.
like a young child. Yeah.
Yeah, you're still not,
no guarantees.
No
guarantees.
Because it all goes with evidence with a dementia patient. So fortunately with dementia patients, we don't need, we don't need, IEPs. We don't need IPPs. But what we do need is eyewitness accounts and we need medical documentation. So, and a lot of times when I'm in a hearing with a dementia patient, I do the hearing by a WebEx, which is like Zoom for the judges, because I want the judge to see how severely. But I've even done that and had them deny.
Yeah, I would say just in general, and again, we got to keep going, but dementia, it's like perhaps a lower bar to prove the need for protective supervision, but the evidence is oftentimes not as readily available,
right,
as you would get for a young child. All right, Alyssa said, can you utilize your current regional worker, or if your child is also a foster child, can you utilize their social worker?
Yes.
Yeah, regional center. I mean, I will say oftentimes the worker at regional center, the caseworker, is not always available for more than just providing,
well, they're not always
a few
allowed
documents.
to go to court.
They're not always allowed to be part of your assessment or your hearings or to write letters, but I'd say, in whatever way they're willing to, absolutely, right? Callie said, we had a lot of great comments here, by the way. I really appreciate everyone. I had asked for my regional center caseworker to be with me because they have their own IPP assessment. Yeah, I mean, like we were just saying, if they're willing to be there at the assessment, that'd be excellent.
And they're a witness to what took place too.
Exactly. Jocelyn said, thank you for the advice. Thankfully, I have one of you as my advocates already.
Good.
Glad that we can help you. Linda said, Mitchell was present for her assessment. We love Mitchell as well.
He's amazing.
Oh, look at all these comments. Callie said, I was told by IHSS my child's traumatic brain injury with half of his frontal lobe missing is not mental impairment.
What?
Okay, so to give
traumatic brain injury is.
To give a little background context, there is a part of the regulation that says that you cannot get protective supervision for a need caused by a medical condition.
That's not a need caused.
This is not what they're talking. This is not what they should be talking about. What they mean is if you've got a heart condition, or you're on dialysis or diabetes or something like that, and you got to be watched all the time for various medical issues.
Call me. I want that case.
Yes.
That one.
Get on our calendar if you can, because when someone, I actually had a client who had traumatic brain injury, and it caused, like, the injury itself caused a mental impairment. And for that, he could get protective supervision. It is absolutely ridiculous for them to say that a traumatic brain injury, that's a medical condition, so so nothing that he does is. Sorry, we're frustrated on your behalf because that's ridiculous that they told you that.
Yeah.
Okay. Linda said, I used the self-help through the courts for the conservatorship, and it was no cost to me. Okay.
There you go.
I think what we had said, and this is a big part of it, is that the exact circumstances of your child and the family might change a lot. Like if your child is more high functioning, or there's other family members who might challenge the conservatorship process, that might create more of an issue than if you have a very low functioning child who very obviously needs conservatorship. Would you say that's accurate?
We should have another talk on
the
conservatorship.
Difficulty of doing it yourself might depend on your particular
Well,
circumstances.
it also depends on how many people could contest it. If it's going to be contested, you need an attorney.
Okay. This next comment, I can read most of it. I think part of it's got cut off. So Teresa, if you can pull up the rest of it after I've read this part. My son's Zoom hearing was October 9th, still waiting on decision. Judge asked the hearing representative and the social worker if what I said will change their minds, and they both said no. County position statement, hearing representative used my son's ABA 6-month progress report, and the social worker used his March 6-month progress report. I told the judge I gave them a March and why they used they used the previous year's progress report. Said I gave them the March one and asked why they used the 2024 one in the position statement, and the hearing representative told the judge she must, and the rest of it's cut off. Teresa, do you have that comment?
Well, I could probably
Teresa,
answer that, and then we have to go because the Spanish
you're right.
team is coming. What I'm going to say is you have to remember that when you're at your hearing, documents that have good weight for the judge are documents that come from the era when you had your home assessment. So if your hearing is in, let's say, June, but your assessment was the previous January, then you need documents from around December, January, February. Anything newer is considered new information, and a judge is not going to entertain that information.
Okay, like you said, we're running out of time, but I do want to end with Teresa's comment here. She had a question I think might be a fun one to end on. Maybe not fun, but she said, without naming names, what is the worst court denial reason you've heard?
Oh, the very worst.
Very worst you ever heard?
Is when they have said, and more than once I've heard it, that eating their feces is not something. And we had a kid with a picture holding a log, and it's all over their face and their hands, and they're eating it.
Oh my goodness.
And having a judge say, that's not dangerous. That's nothing to be concerned about. Or I think those are the most. You read all the decisions.
I've got two. I've got two.
That.
One is not protective supervision related, but it bothers me. It's bothered me for like 3 years now.
Which one?
It is one where it was a child with cerebral palsy who was 6 years old, and she needed help with all kinds of dressing. She needed help, with shirts and pants and the whole 9 yards. And additionally, she also wore a leg brace.
I know what you're going to say.
You know this
I know
one.
which case.
I've mentioned it so many times. But she wore a leg brace. And at 6 years old, you can get time for dressing.
Mm-hmm.
And you can get time for paramedical services. Mm-hmm. And the judge went down, looked over all the testimony, all the evidence, and broke it down piece by piece and said, this child is 6 years old. They're old enough to get time in the dressing category. They have a physical condition. They have to have help with dressing. They have to have help with putting on their leg brace. The leg brace is part of dressing, and it is even a paramedical task. It is over and above the normal amount of dressing care that's required. Mm-hmm. The mother has to do it for her. It takes extra long, whole 9 yards. Went through all of this and said that at 6 years old, dressing is not a parental responsibility. And then conclusion, we will approve no time in dressing because it's a parental responsibility. So step by step by step explained exactly why this child will get time in dressing, and then conclusion,
why
you get no time. And I to this day, I don't even understand why.
I don't even read the decisions. I have him read them because I put so much of myself into every hearing, hours and hours. I talk to social work. I mean, the appeals field. Parents don't know this, but I spend so much time before they even talk to me. So then when we get a negative decision, it's like, I can't read it. Mm-hmm. I get so mad.
And I'll say my second one. The second one's protective supervision related. This is probably the worst logic or decision I've ever heard related to protective supervision. Was, and I've seen it a couple of times, this child, it's usually a very young child when they say this, will elope. They'll elope out of the door, right out the front door. It says, however, in order to elope, this child had to know where the front door was, had to know that the front door led to the outside. They had to have a desire to go outside. They had to walk to the front door. They had to reach the doorknob. They had to turn it and pull it at the same time. They had to know that turning and pulling it would open the door. And they had to do all of those things in order to elope from the home. And so because they did all those things, they showed judgment in a lot of different ways. They showed orientation in knowing where the door was. Therefore, they actually have good judgment and good orientation when they decide to run out of the front door and into the street.
So you all know what we are up against.
These are the things that frustrate us to no end. And that's why when we say right now for a young child, you've got a 5%, and it's probably, for those who are not being represented by an advocate, it's probably much, much less.
Now, we do win a lot in the home assessment for 3 and 4-year-olds. We even won 2-year-olds.
Yeah.
But not in front of judges. So if we get your case and your case is young, we're not going to, if we think it's a good case, we're not going to throw it out, but we may not go to hearing. We may say to you, let's go back, see the social worker, and we'll be with you, and we're going to help you have all the right documentation. We got to go because the Spanish
we got to
team
go.
is
It is
coming
time for our Spanish Live. And so we're going to say goodbye. But if any of you speak Spanish, you can join Myra and Nicole, I believe, today, where we're going to talk about the same topic. If there are any questions you didn't get answered, you can ask them in Spanish. All right. Goodbye,
All right.
everybody.
Bye. Happy holidays, everyone.